27th, hearing item.
Yes,
This matter will be listed on 27th of this month,
27th of this month,
Tuesday.
Tuesday.
Yes.
Any objection?
No.
Yes, agreed by learned advocates of both the parties. Recessal list the matter on Tuesday.
Listen into the
Interim order passed earlier shall continue.
Lordship, I have another matter, item number 11.
Yes,
Here I have to file a affidavit. So 2 weeks time will be granted for this.
Mr. I.M. Sung, learned additional lazy with consent from the other side. Press for listing the matter after 2 weeks.
2 weeks.
So as to enable him to file affidavit in opposition. Pair allowed to recessal list the matter after 2 weeks.
Lordship, I have item number 17. Here also, I have not yet received instruction. So 3 weeks time will be granted in this matter. Item number 17.
Okay. Mr. I.M. Sung with learned additional lazy with consent from the other side. Press for listing the matter after 3 weeks so as to enable him to receive instruction. Pardon?
There is interim.
Pardon?
There is interim.
Interim. Okay. Okay. Interim order passed earlier shall continue.
One more item number 7. Here, I'm yet to receive instruction.
Mr. I.M. Sung, learned additional lazy with consent from the other side. Press for listing the matter after
2 weeks.
after 2 weeks so as to enable him to obtain
Your Lordship, it has
to
been
receive
years.
instruction.
It has been years since this written
Yes.
petition has been filed, so at least
I agree.
an effort has to be made. If not, for about 2 years, the same has
Okay.
been going on, my lord.
Mr. Seki, learned counsel for the petitioner, however, submits that since 2 years,
My lord.
the respondent authorities have failed to file their affidavit in opposition. And accordingly, taking note of the submission of Mr. Seki, learned counsel for the petitioner, Mr. Im Sung is granted last opportunity
My lord.
to file the affidavit in opposition, and in the event of failing to file the affidavit in opposition before next date, the court will proceed to hear and dispose of the petition on the basis of the materials available on the record.
My lord. Lordship, Lordship.
May I please, madam?
Yes.
Lordship, I beg to mention item 12. If 3 weeks time can kindly be granted to file my counter affidavit. I have taken the consent from the other side, madam.
Mr. Sunson, learned counsel for the state respondent with consent from the other side, press for listening the matter after
3 weeks, madam.
after 3 weeks. Fair allowed.
I'm deeply obliged, madam.
Yes, Lordship. I may be allowed to mention item 34 from the supplementary list, Your Lordship. Yes, Your Lordship. In this matter, Your Lordship, I have not received the full instructions. So I may be allowed to receive the full instructions and I'll be file it by 2 weeks, Your Lordship.
I'm appearing for the petitioners in item number 34, my lord.
Yes.
This writ petition was filed in the month of September, my lord. Till date, they have been taking time to file instructions. It has already been listed half a dozen times, and every time they are taking time for instructions only.
Heard Mr. Verma, learned counsel for the petitioner, and Madam,
In a holy, Your Lordship.
learned counsel for the state respondent. The learned counsel for the state respondent submits that she has not received a full instruction, and as such, she press for listing the matter after
2 weeks, Your Lordship.
after 2 weeks so as to enable her to receive the instruction. Pair allowed.
Your Lordship, I may
Recessal list the matter after
2 weeks.
2 weeks.
As a final opportunity, my lord.
This writ petition is of the year 2025.
Yes, Your Lordship.
Yes,
And
my lord. Yes, my lord.
Your Lordship, and item 30 as well, Your Lordship, on behalf of my colleague, Your Lordship, from AIME, since she's indisposed, this matter may kindly be listed after 2 weeks.
Item number 30.
30, Your Lordship.
30. Any objection?
No objection, Lordship.
Heard Mr. Walling, learned counsel for the petitioner, and Ms. Inahole, learned government advocate for the state respondent. You are for
Private respondent number 7.
private respondent number 7. You,
For respondent number 8.
respondent number 8. Ms. Inahole submits that this matter was assigned to
IME.
and she is indisposed of, and as such, she pressed for listing the matter after
2 weeks, Your Lordship.
after 2 weeks. Fairly.
Mr. Lordships. Lordship, I beg to mention item number 27, hearing item number 27, Your Lordship.
27.
Yes, Your Lordship. I'm making a
27 already mentioned.
Apologies, Your Lordship. 28, Your Lordship. I'm for
28.
respondents, Your Lordship.
Okay.
Lordship, I beg if this matter could be listed on next week, Your Lordship, as the arguing counsel is indisposed today.
Okay. Mr.
Chingyang Pong, Your Lordship.
Learned counsel appearing on behalf of learned CGC with
All
consent from the other side, press for listing the matter after 1 week.
Yes, Your Lordship.
After 1 week. Fair allowed.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship. 18.
18.
Lordship, I have taken the consent of the government. 1
Okay.
I have taken the consent of the government advocate, Achungli Sangdam. So if this matter may be listed after 3 weeks, Lordship.
Okay. Mr. Your name, please.
Laknai Pom, Lordship.
Learned counsel for the petitioner with consent from the other side, press for listing the matter after 3 weeks. Fair allowed. Is there any interim?
No, Lordship. No.
Okay.
Lordship, I also like to mention item number 20, Lordship.
Item 20.
Lordship. Lordship, actually, I'm supposed to file an IA for implement of necessary party, but I couldn't contact my client, so some time may be given, Lordship. 3 weeks
Okay.
time.
Heard Mr. Swenson, learned counsel for the petitioner, and Ms. Levika for the government advocate. Government advocate for the state respondent. The learned counsel for the petitioner submits that he could not contract the petitioner, and as such, he could not file interlocutory application for
Lordship.
impleadment.
For implement, Lord.
For impleadment, and as such, he pays for granting him 2 weeks time. Where is accordingly allowed. Recessal is the matter after 2 weeks.
Obliged, Lord.
Maybe please to mention hearing item number 23, 24, and 25. Your Lordship, the petitioner also contacted me this morning that he is out of station. So accordingly, Your Lordship, the matter can post it after 3 weeks, Your Lordship.
You are for the petitioner.
No, I am not for petitioner, I am for the state, Your Lordship. However, Your Lordship, the petitioner also contacted me this morning.
Okay, okay,
It's a consensus for
okay.
3 weeks.
On the pair being made by Ms. Levika, learned government advocate, the matters is that's adjourned to be listed after
3 weeks.
3 weeks.
Make this your Lordship, I beg to mention hearing item number 51, Your Lordship.
Item number
31, hearing item number 1. Taking consent from the other party if the matter may be listed after 3 weeks, Your Lordship.
you are for the petitioner.
And for the respondent number 3, Your Lordship.
Respondent number 3. Miss, your name please.
Kim Piano.
Learned counsel for the respondent number 3. Any objection?
Lordship, I have no objection.
With consent from the other side, press for listing the matter after
3 weeks. Your
after
Lordship.
3 weeks. Fair allowed. Recessal is the matter after 3 weeks.
Now, Mr. Lordship. Lordship, I beg to mention item number 32, Your Lordship. I'm for a private respondent number 6, Your Lordship. This matter could be passed over, Your Lordship.
Mr. So-and-so, learned counsel for the respondent number 6. You inform the other side?
Your Lordship, I've been trying to communicate with the other councils, but it seems they are not with the board.
Okay. They may present,
But Your Lordship, I'll inform.
we'll call the matter later on.
Thank you, Lord. That's the Lord. My Lord, about mention number 9. Lord, I'm here. I've received the affidavit of the respondents. I need to file my reply. Can you grant me 3 weeks time to file my reply, man?
You are for respondent number? Oh no, for the petitioner, okay. Mr.
Nine.
Jessica Hotel, learned counsel for the petitioner, submits that he has received the affidavit in opposition
Opposition of the government.
of the state respondent and he will file a reply to the same. And he applies for granting him
Got 3 weeks, my lord.
3 weeks time. Fair allowed. Fair allowed. Madam, you are for? Respondent number? Four.
I will also file.
And Madam for the state respondent.
I will also file affidavit in opposition.
You will file your affidavit in opposition.
Yes.
Okay, you may file. You may file.
No, the state is fine.
The state
It
is.
says file, but the private respondent doesn't get the file.
They are the petitioners. I
No,
am
that's all right.
responsible by private.
You also want to file affidavit.
In opposition, yes.
Yes, you file it.
Yeah.
Miss Jimomi, learned counsel for the private respondent number 5.
4, right?
4 submits that she will also file affidavit in opposition in this matter and press for granting 2 weeks time.
3 weeks, my
3 weeks time. Okay.
What's the interim? Can we
Interim order pass earlier shall continue.
My pleasure, Lordship. Lordship, I beg to mention item number 2.
Item number 2.
For the union.
For union.
Lordship, I am for respondent number 1.
Okay.
Yes. Lordship, kindly grant us 2 weeks time to file our reply to affidavit in opposition.
Okay. Heard, Miss? Learned counsel for the petitioner and Madam Levika
For the state, Your Lordship.
is the respondent and Mr.
Sharif Ahmed, Lordship.
Learned counsel for the respondent number?
1, Lordship.
Respondent number 1. The learned counsel for the petitioner submits that
2 weeks time to be granted.
that she may be granted 2 weeks time to file
Our reply
to the affidavit in opposition filed by the
Yes, Your Lordship.
State.
State respondent. Okay. Fair allowed. This is unless the matter after 2 weeks. 2 weeks.
Lordship.
Lordship, I beg to mention item 22. If it can kindly be listed on Tuesday, 27th of January, Lordship. The matter has
Item
almost-
number 22.
Yes, my lord. It has become almost infructuous, but there are certain documents which I want to place on record of this honorable court before we close the matter. So if it can
Okay.
kindly be listed. And
On the pair being made by Mr. Sanctier, learned counsel for the petitioner, the matter stands adjourned to be listed on next Tuesday.
Yes, my lord, 27th. Lordship, there is an interim.
Interim order passed earlier shall continue.
Lordship, in item 8.
Item number 8.
Yes, my lord, I am here to file my affidavit in reply. If I may finally granted 4 weeks, my lord.
Okay. Heard Mr. Sanctier, learned counsel for the petitioner and Mr. Imsam, learned additional legend for the state respondent.
Lordship, I have
Santi Younger submits that he will file a reply to the affidavit in opposition filed by the state respondent
my lord,
and a price for granting him
4 weeks, my lord.
4 weeks time. Fair allowed.
Lordship, I have similar prayer for item 10. Here also I made to file my reply,
Okay, similar order.
my lord. Deeply obliged.
May it please your Lordship. Lordship, I beg to mention item 5, Lordship, on behalf of the petitioner. I've been instructed that they have informed the opposite party and we have a consensus prayer if this matter may be listed after 2 weeks, Lordship.
Okay. Mr.
Week was our Lordship.
Learned counsel for the petitioner.
Petitioner, Lordship.
With concern from the other side, press for listing the matter after 2 weeks.
2 weeks, Lordship.
After 2 weeks. Fair allowed.
Lordship, I also beg to mention item 19. Here, I am for respondent number 5, Lordship. I've yet to file my affidavit in opposition.
Mr. So-and-so, learned counsel for the respondent number 5. You inform the other side, petitioner?
No, Lordship. I've been trying to find out, but since
Okay. Any objection?
No, my lord.
With consent from the other side, first of all, listing the matter after
2 weeks, Lordship.
so as to enable him to file his affidavit in opposition.
Lordship,
Fair allowed.
much appreciated.
Much more.
Members of Lordship, Lordship, I beg to mention item number 15. Here I get the receipt instructions, so if 3 weeks time we grant credit to it.
You are for the respondent.
Lordship, 15.
Miss, your good name, please.
Pijano,
Learned counsel, learned government advocate
Lordship.
for the state respondent.
No objection.
With consent from the other side, press for listing the matter after
3 weeks.
after 3 weeks, as she have not received any instruction from the respondent authorities. Fair allowed.
Lordship, similar prayer with item number 16.
Okay, similar pair. Same order.
Lordship, item number 4 as well, on behalf of S. Chang. Kindly desist better after 3 weeks.
Ms. So-and-so, learned counsel appearing on behalf of Ms. S. Sang,
Lordship.
learned government advocate for the state respondent. With consent from the other side, press for listing the matter after 3 weeks.
Lordship.
3 weeks. Fair allowed.
Lordship.
Lordship, item 13 as well, on behalf of S. Chang. Kindly desist better after 3 weeks.
Lordship, this is also a same line as the Masik Rafiq case. They are in
Yes.
service, they were paid 3 years or so extra money, extra salary. The petitioners are teachers. And so this can also be disposed of on the same line, Lordship. This item number 13 is the same. They are teachers. And even the state government has adopted not to recover any salary from the petitioners. There is a notification. I have annexed that also in my writ petition. Instead of filing affidavit.
Lordship, I'm instructed that she's yet to file the affidavit, so if sometime we have that.
No, is it necessary? Because the law is well settled.
Yes, yes.
Hmm? Why should we keep the matters pending?
Lordship, I'm on behalf of my colleagues.
No, that's all right. But
Uh,
whether your affidavit will change the legal position or not.
Exactly.
Lordship, that if this matter will listed for next week. So
Next
that,
week.
she can come and appear, Lordship.
Next week. Okay.
Then on
Okay,
Tuesday.
next week.
Tuesday.
Tuesday, okay.
Tuesday.
Tuesday. Okay.
Lordship, item number 6 on behalf of S. Chang. Kindly for 3 weeks time to file affidavit.
Okay. Similar order. Any objection?
No, Your
No.
Lordship.
Okay.
Lordship, I also like to mention item number 26 on behalf of Vizimo.
On behalf of
Vizimo.
item number 26. Okay.
He's
Similar
yet to
order.
receive the instructions, so.
You are for petitioner? Any objection? No.
No, Lordship, I'm not.
Okay. Same order.
Lordship, item number 14 as well on behalf of Arjun. Kindly this is whether after 3 weeks.
Okay. 3 weeks.
I blush.
Please, Your Lordship. I'd like to mention item number 21. I'm appearing on behalf of my senior, Mr. Siti Jamir. We've received the affidavit in opposition, so if 3 weeks' time may be given for us to file.
Miss, your good name, please.
Jawa Mongyedan.
Learned counsel appearing on behalf of Mr. Siti Zome. Learned senior counsel for the petitioner submits that the petitioner will file affidavit in reply to the affidavit in opposition filed by the state respondent. And she prays for listing the matter after
3 weeks.
after 3 weeks. They are allowed. Mr. I am some learned additional lazy for the state respondent.
Yeah, please, Your Lordship.
Yes.
I beg to mention item number 29. Lordship, I'm appearing on behalf of the leading counsel for the petitioner, Mr. Pakim Chapo. Lordship, the leading counsel for petitioner, he is a little busy today. So if the matter could be listed after 2 weeks.
Mr. Your name, please.
Pangut.
Learned counsel appearing on behalf of Mr.
Pakim
Pakim
Chapo.
Rishoba. Learned conducting counsel for the petitioner with consent from the other side. Press for listing the matter after
2 weeks.
after 2 weeks. After 2 weeks. They are allowed.
Lordship, similar prayer for supplementary cost list item number 33. Lordship, if the matter could be listed tomorrow.
Tomorrow. Okay. Mr. So learned counsel appearing on behalf of Mr. Baken Rishoba, learned conducting counsel for the petitioner, press for listing the matter tomorrow. Fair allowed.
Ovation.
For motion, item number 1.
So, madam, where is the notification of the state government?
That
Page
is in
number?
that is in the item 13. That is for grade 4, grade 3 and grade 4 employees.
Okay.
That is regarding grade 3 and grade 4.
Here you have not
They are gazetted officers.
gazetted office.
Yes,
Okay.
Lordship, subdivisional officers. So my case will be covered by paragraph 18 of
Rafik Mas's case.
yes, Lordship.
So they have been issued this payslip by the accountant, office of the accountant general,
Office of the Accountant General, AG.
AG.
Yes, Lordship. We are implementing this because in most of the cases, in both the same cases, because AG has 2015 for SCC. For SCC 334.
Anybody appearing for the AG today? No. Have you served copy of the?
Of course, Lordship.
You have served.
Yes.
In that case, would it be proper to dispose of the matter without hearing the AG?
The learned counsel has also shown his appearance. Their counsel is as Moji. Mr. Moji is their counsel.
Is he present in the court today?
Present now. Then I'll give them notice, and it may come up on Tuesday together along with Tuesday.
Okay. Today we will issue notice.
Yes. I will give the notice has not been issued, so I will give the written petitions to the opposite parties.
Heard Ms. Z. Jimovi, learned counsel for the petitioner, and Ms. Ina Hole,
Yes, Your Lordship.
learned counsel for the state respondent.
1, 2, and 3.
1, 2, and 3. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the paragraph number 2 of the notification dated 8/11/2021 in respect of the petitioner number 1 and the notification dated 3/10/2023 in respect of petitioner number 2, 3, and 4. And also rightful issuing direction to the respondent authorities not to make recovery from service. No, not to make recovery of the excess amount paid to the petitioners.
It's not excess, their promotional post. They want to recover from their officiating promotion post
So,
to the
from
post
the
of SDO.
officiating promotion post. From the existing monthly salary of the petitioners or from pensionary benefit at the time of their retirement. The learned counsel for the petitioner submits that the petitioners are serving as subdivisional officer and petitioner number 1 and is serving under Directorate of Tourism and petitioner number 2 under the EE Urban Development and petitioner number 3 under the EE Agunatu Division and the petitioner number 4 under the EE PWD within bracket English Mukoksan Division. And the petitioners were appointed as SO grade 1 through NPSC and subsequently White letter dated 13th of May 1997. Their posts were upgraded and redesignated as junior engineer class 2 within bracket class 2 gazetted. And after serving as junior engineers in between now for about 9 to 16 years, their services they were officiating they were granted officiating promotion to the post of SDO by notification dated 10th of July 2007. And the petitioner number 2 was granted officiating promotion to the SDO by order dated 4th of January 2013. And they have served more than 10 years as officiating SDO.
For 10 to 14 years. In between 10 to 14 years.
Where you have mentioned it?
I have not mentioned, but in there, in the main writ petition, it's there.
More than a decade as officiating SDO. White common notification dated 8th of November 2021 and 3rd of October 2023. And they were finally regularized by the DPC. However, in the paragraph number 2 of the impugn notification, it is stated that within inverted comma, the pay and allowances already enjoyed by the officials who have superseded their seniors shall be recovered and refixed as per the date of regularization of their officiating promotion. Inverted comma close. The learned counsel for the petitioner further submits that being aggrieved, the petitioners have filed one representation dated 22nd of July 2024 to the respondent number 2. But the same failed to evoke any response. Though the respondent number 2 has written a letter to the respondent number 3 requesting to examine the appeal of the petitioners. The learned counsel for the petitioner further submits that the petitioner number 2, the person who has retired, he is not petitioner here.
No, but he's not petitioner.
Submits that one of the colleague of the petitioners, whose name figured at serial number 3 of the impugn notification dated 3/10/2023, also filed one representation dated 22nd of July 2024, is retired from service. And the petitioners came to know that the respondent authorities have deducted the amount from the pensionary benefit of his officiating period as SDO in spite of submission of the aforementioned appeal. And being aggrieved, the petitioner has approached this court by filing the present petition. The submission of learned counsel for the petitioner needs further consideration. At this recess, notice be issued to the respondents returnable on Tuesday.
Your Lordship,
Tuesday.
maybe also given some time to receive instructions. So on Thursday, Your Lordship.
Thursday. Returnable on Thursday. Since Ms. Inaholi entered appearance for the state respondents number 1, 2, and 3. No formal notice is required to be issued. However, extra requisite copy of the petition may be furnished to her during the course of the day. Step upon respondent number 4 be taken by registered post, no, by speed post, and also by usual process. List the matter on Thursday
Thursday, as a fixed item.
as a fixed item.
29. Obliged, Lordship.
For admission, item number 3.
Thank you very much. Before I have to give the background of the matter, Your Lordship. What has happened, Your Lordship?
Mr. Sudhuri,
Yes, Your Lordship.
this petition is under Article 227.
Yes, Your Lordship. Yes, Your Lordship.
But you see, when alternative remedy is available under section 115 of the CPC.
No, so revision, it's an interlocutory order.
Pardon?
It's an it's 115 won't apply. Because it's not it's an interlocutory order, Your Lordship. 115, that's why 227 I have to file. Neither I get 104 nor I get 115. That's why 227.
Revision will not lie.
No, interlocutory revision. No.
No, is it interlocutory order?
Yes, sir. Interlocutory. An interlocutory. Interlocutory in a pending suit, I move an application seeking certain documents from them. Order 11, 12, and 14. So it's an interlocutory order. Nothing. That's why 227 comes. Yes, otherwise, I checked out. But then query was put when the matter was filed also. And I showed that it's because neither 104 is applicable here, nor I get 115 also. That's why 227 is the only remedy available to me. That's it.
Lordship, in the petition posted, it is clearly mentioned that an application under Article 227 of the Constitution of India with 115 of the CPC.
Main is 227. Main is 227. Rarely I can leave it also.
It is readily observed that there is already remedy. No, we go for appeal or any revision against the order passed by the Indian Court. And then before my learned friend proceed, he has emphasized on the error of the non-observation of the Learned Court below. So I feel that it will be appropriate if the LCR is called.
LCR is there already. LCR is there. LCR is there. LCR is there. LCR is called. LCR is called. No, that's not so.
LCR is
just called actually. It needs. Order was there. I told you. No, it was not.
It's not received now. Is it whether LCR is necessary?
Because he has emphasized on non-observation of the submission made by them, and then
It is on record. The order clearly reflects the impugn order clearly reflects all the things.
And where is the
impugn order clearly reflects all those things. I have made the submission. Your Lordship is very because one thing in this application, Your Lordship, which I filed under the CPC,
a specific schedule of affidavit has to be filed, which has not been filed. That is one of the specific objection. Because CPC, if your lordship take order 11, rule 13, your lordship, if your lordship see. Just order 11. Order 11, sorry. Rule. Order 11 is just give me a minute. Order 11 is regarding the order 11, rule 13, your lordship. 13 says, because 12, I have made an application in another 12, your lordship. Application for discovery of documents. My lord has got it. Any party may, without filing an affidavit, apply to the court for an order directing any other party to make a suit for to make discovery on of the document which are on have been in his possession or power relating to any matter in question therein. On hearing of such application, the court may either refuse to attend the same if satisfied and the discovery is not necessary or not necessary at the stage of the suit, or make such order either generally or limited certain documents as may be discussion. Provided the discovery shall not be ordered when the court, so far the court as shall be opinion in the court not as
Mr. Sodra, you were referring to order?
Order 11, rule 12. Sorry, order 11.
Yes.
My lord has got it. Where is 12 again?
Yes, yes.
Any party may, without filing an affidavit, apply to the court for an order directing any other party to any suit to make discovery on oath of the documents which are or have been in his possession or power relating to any matter in question therein. On the hearing of such application, the court may either refuse to adjourn the same if satisfied that such discovery is not necessary or not necessary at the stage of the suit, or make such order either generally or limited to certain classes as may be discussed through. Provided that the discovery shall not be ordered when the so far the court shall in the opinion that it is not necessary either by disposing fairly of the suit. 13 is important. Affidavit of documents. The affidavit to be made by a party against whom such order is mentioned in the last preceding rule has been made shall specify which any of the documents therein mentioned he objects to produce, and it shall be form 5 appendix C with the variation as circumstances. Your lordship, this form of evidence has been specified in CPC, or that is appendix C. Your lordship see that is at affidavit is at, if your lordship will see, it is, if your lordship will just schedule. Schedule, if your lordship goes, it is schedule is number 5, your lordship. If you lordship see the schedule, if you're in here, and serial number 5, affidavit of documents, if you lordship see toward the end, is there. My lord has got it. If your lordship pass it, I can find it otherwise. Otherwise, it's very, you got lordship got it.
Schedule?
Number 5, your lordship. It's appendix C. Appendix C, number 5. Yes. 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 Right. 5. Right and down below it.
This book is different from your book.
I'll find it. I'll find it. What person? Give me that.
Affidavit has to document.
Yes, sir. I'll just find it. I'll give it. Very difficult to find out. It's on the left hand top, I should say.
Okay.
I'm sorry, Your Lordship.
No problem.
Here, if Your Lordship see, affidavit has two documents, order 11. I, above no depend so and so paid what following. I have in my possession or power the documents relating to matters in question in the suit court in the first and second part of first schedule thereto. I object to produce the set forth in the second part of first schedule thereto. I have had but have not now in my possession or power documents relating to matters in question suit set forth second schedule hereto. The last mentioned document was the last in my possession or power it said when and where it becomes necessary so and so. According to best knowledge, information I have not now and never had in my possession custody of or in their possession custody of my leader agent or the possession custody of or any other person on behalf on account of the book account, voucher, receipt, letter, memorandum paper or writing or any copy of extract of any such document or any other documents whatsoever relating to matters in question in the suit or any of them or where any entry has been made relating to such matters or any other than except the documents for schedule taken. Now, Your Lordship, there the affidavit filed by them is annexure P4, Your Lordship. This doesn't comply. Annexure P4, Your Lordship, that affidavit.
No, is it available on the record?
No, this is here. The affidavit is not in conformity to this. It is annexure page 45. Their affidavit to the application. Your Lordship. Annexure page 45, Your Lordship. It starts with page 45.
Yes.
This is the affidavit, Your Lordship. It's not compliance to order 11 rule 13, Your Lordship. This is the specific objection raised before the trial court and recorded it, but not discussed it. Trial court order also said that this was raised.
The learned trial court has held that it is not necessary to adjudicate the dispute in the suit.
So Lordship, see page 55, that's objections raised, page 55 of the MP order. She has not said anything on that. Page 55, Your Lordship, see? Page 55. Without seeing the document, how can you say it is not relevant? That is also an issue here. If you also see page 55, it is submitted, the defendant ombudsman has not filed an affidavit in terms of order 11 rules and inform 5C appendix C. It is submitted in this context, the discovery of in the custody of defendant are relevant for necessary determined dispute raised in the presence of. Specific pleas are there. Unless the documents are there, how can the learned judge decide it's not relevant without seeing the documents?
No, the learned trial court has considered the pair
Yes.
being made in the suit.
No, it's they have made in the prayer, Your Lordship, what is happening? What I referred, because I say it was a conditional bank guarantee, Your Lordship. Conditional bank guarantee, and in case of conditional bank guarantee, the condition has to be such as before encashment of bank guarantee. What has happened, Your Lordship, let me give the background. What has happened, Your Lordship, in this case, a tender was floated for construction of 13 border outposts, Your Lordship, in Mizoram, bordering Bangladesh, Your Lordship. What has happened? Tender was floated and petition was floated by respondent number 2, and petition was successful, and it worked around 64 crores was given, Your Lordship. For that same purpose, the petitioner has to give bank guarantee to the tune of 6.4 crores, Your Lordship, which while it was given in the name of so and so. It was this bank guarantee is only for recovery, a mobilization advance is given, that is for that purpose only. If the mobilization demand is there, then only the saving is there. Here, Your Lordship, there is no demand for mobilization advance. What has happened, Your Lordship? Before the contract was terminated, on the same day, this bank guarantee was encashed, Your Lordship. What has happened, Your Lordship, in this matter? Even our witness has been cross-examined. When the list of witnesses was given by them, they gave the present bank manager, who doesn't know anything about the matter. And we moved an application before trial court, seeking that person who were there at that relevant point from 2011 to 2017 till 3/11/2017. That officer in the manager, he and other officers who were there are to be examined, not this person, because he won't be able to tell anything of the record. What has happened? Then the court has passed an order directing that those people should be examined. That was the order. Subsequently, when they stood, the documents are also necessary as to what steps were taken for encashing of the bank guarantee, Your Lordship. Those documents, because 6.5 to 4 crores won't be just give the bank guarantee and it will be recovered. There is a process that the process of the documents are called for it. So that is very much necessary, because what has happened, my case is because the illegal encashment of the bank guarantee, I have to pay interest to the bank. And that I have to recover, because I say it's illegal, the bank has to pay me the interest. So for that determination, these things are required, Your Lordship. How is he can say it's irrelevant document? Because this is connected to the other. Otherwise, how 6.4 crores are encashed? The whole process corresponding, everything has to be given, Your Lordship.
No. What was the pair in your
there in the
suit?
It is there, Your Lordship. It is there page. I just
The plaintiff is not part of this record.
Plaintiff is not there.
Then how can we examine
But
the
extract, I have extracted the prayer also, Your Lordship, see. It is at page 13, Your Lordship.
Page 13.
13, Your Lordship. The prayers page, the prayers are as follows.
Yes.
A decree for rupees 85 lakhs 22 crores 22,608 in favor of the plaintiff and against the defendant along with component per annum paid by way of interest as a result of interest encashment. Then a decree for so and so in favor of against the defendant of so and so along with compound interest accrued for a period 26 to 31 by interest as a result of illegal encashment. So this was also encashment. A decree for interest both pending and featureless. So these are the prayers here, specific prayers. I have to recover the interest from the which I have to pay to them because of illegal encashment of bank guarantee. So that's a limited issue in this matter. Because without these documents, all these documents, I am not able to prove that or prove these things here. These documents are in their possession between which is a correspondence between the respondent number 1 and 2. I am not a previous party to that, and I am the sufferer, Your Lordship.
No, bank guarantee was given by whom? You.
No, I have given. Bank
So
guarantee.
how you are not a party to the same?
No. Regarding encashment, I am bank guarantee was given by me in favor of respondent number 2, Your Lordship. For recovery of mobilization advance. There's no demand for any mobilization. What they do, they first went for encashment of bank guarantee on the same day and thereafter terminated the contract. So in fact, it is a conditional bank guarantee. So since it's a conditional bank guarantee, it cannot be encashed. If it is an unconditional bank guarantee, they could have encashed. But it's a conditional bank guarantee which is subject to a condition that it is related to mobilization advance only. Because the bank guarantee is clear in that figure here also.
So how this order of the trial court?
Yes, Your Lordship.
Suffers from any illegality or infirmity requiring interference.
Because one thing is that they have not decided the issue, Your Lordship, because Supreme Court judgment is there, I have referred to it. Or if Your Lordship wants a record also, that could be called for. If Your Lordship wants to see the records, trial court records, you may call for it. Yeah. Your Lordship is why, otherwise without the trial court records can be decided also, because if Your Lordship wants to see the records, that also can be brought in, that's no problem at all.
Yes, what is your submission?
Lordship, as my friend has submitted for more clarity, if the LCR is quote, because he is challenging all the infirmities.
No, you say if we call for, is there any stay?
Stay
is there.
Yes.
Well, let the record come then.
Okay, Your Lordship.
Because you have not enclosed the copy of the
Yes, no,
suit.
if Your Lordship wants it, it's no problem at all. Let the records. Let the entire record come there.
Or Mr. P. Choudhury, learned counsel for the petitioner, and Mr. Learned counsel for the respondent. After hearing learned counsel for both the parties, perusal of the record of the learned trial court is found to be necessary, and accordingly it is provided that recess shall call for the record from the learned record of
civil just
suit number.
Suit number is MS number 10 of 2018. Money suit number
10 of 2018.
Pending in the court of Civil Just Senior Division.
Along with IN number.
On the record, on entire records.
Entire record of money suit number 10 of 2018.
The
along with IN number 367 of 2022. Fixing the matter on when? 23rd February. Interim order passed earlier shall continue.
Deeply obliged. Yes, sir. Because I also want that bank guarantee has to be, because it's a conditional bank guarantee, and I can, because without the record, I cannot, because it was, I think, I remember Honorable Justice Marley, she ordered for calling for the record.
When?
Long time back. If it was matter was there, it was engine overloading because of that issue. I think I remember. When the Honorable Judge has asked the trials for report is over. That order was there. Honorable Justice Marley. Well, I prayed before I could bring the record that day.
There is no order passed by Justice Marley.
I think I'm sorry if I mean that also I just if I mean there was some I no problem. There's no. Because I just prayed, I think I just slipped off. No problem. You will actually part of it. Because I was under the impression records are also there.
Okay, on 23rd
23rd February.
February. Okay. Any other matter?
Yes, we have one more matter.
Declare.
For hearing item number 32.
There. Yeah.
Inspector, interim order was there. Interim order.
Order. Continue.
Once I missed it, that's why it was there again.
Sorry, Lordship.
In item number 32, you are for the petitioner.
Lordship. I'm for the petitioner, Lordship.
Okay. You have prayed for adjournment.
Lordship, the respondent, they have prayed for adjournment.
Respondent have prayed
Lordship,
for-
Lordship.
Okay.
And we have a consensus prayer if this matter can be listed after 2 weeks.
After 2 weeks.
Lordship.
Okay. As agreed by learned advocates of both the parties, recess unless the matter after 2 weeks.
Much obliged.
For that day for you. We got that.
No, we have division bench matter at 2. Yeah.
Today.
Yeah.
We have two though.
At 2.
That is why busy or
No.
physically.
Yeah.
Council will come. Constitution council will come.
Part of matter.
I see that. Okay, see you in February.
Okay.
Because it's very difficult to find that position CPC and chat.
Ito na kanina. Backwards the division the tin tao. Our single bench too, dito de.
for hearing.
My lords,
Numbers 1 and 2.
my lords, I'm appearing for in the writ appeal, my lords 7.
Yes.
We need to respond, my lords, to some of the submissions made by
Yes.
the other council. So, my lords, I'll keep it very brief.
Okay.
So that we can hopefully, my lords, conclude it so that your lordship can take care of the necessary, my lords, requirements. So, my lords, one of the submissions made by the other side was regarding the definition of animal under the PC, and tried to say, my lords, that therefore the Food Safety Act also, my lords, relates to the similar definition of PC Act. Now, PC Act, my lords, does define, there's no question about that. But, my lords, we are right now dealing with FSS Act, which itself defines, my lords, animals in regulation 2.5.1,
Which is subject matter.
which is the subject matter, my lords, of the current issue. So, my lords,
PCI definition.
the definition under 2.5.1 enumerates, my lords, the animals. 2.511 was specifically definition. Animal means an animal belonging to the following classes, my lords, and then defines them specifically. It is not a generic definition. It is specific: ovines, caprines, suolines, bovines, domestic rabbits, and then goes on to define further also, my lords, carcass, etc. also. So, my lords, in view of the fact, if your lordship will then take section 89 of the Act, FSS Act, that is an overriding act, my lords. The overriding provision, my lords, overrides all other laws. If I may read it out to your lordship.
Madam, you were referring to section?
Section 89 of the FSS Act. Food and Safety Act means.
Yes.
So, because this, in terms, was overriding effect of this act over all other food-related laws.
Okay.
The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or in any other instrument having effect by virtue of any law other than this act. So, Milords, A, it is defined specifically in regulation 2.5.1. There can be no recourse to any other legislation, Milords, to this effect when a statute itself specifically, Milords, stipulates the conditions. Secondly, in addition, Milords, section 89 overrides in any event all other laws, Milords, relating to the subject matter in hand. And Milords, similar, Milords, the view has been held, Milords, by Ethiopian Airlines versus Ganesh Narayan Babu Sabu, Milords, before the Honorable Supreme Court, Milords. My colleague will, Milords, hand over the judgment to your lordship.
Yes.
Para 65 in this, Milords.
Whatever is not mentioned. Yes.
Whatever is not mentioned, Milords, is excluded. If your lordship will see para 65.
Yes,
This was dealing. The principle, Milords, is expressio unius principle. However, according to the principle of expressio unius, because the legislature expressly made the aforementioned provisions of CPC applicable to the consumer proceedings, the legislature is therefore deemed to have intentionally excluded all other provisions of CPC from applying to the said proceedings. So, Milords, what happened is one particular provision was applied of CPC to the Consumer Act, and therefore the court held that only that provision, because it is expressio unius, which will apply. And in our case, Milords, that we have even a better situation to say, Milords, that we have a specific definition. We are bound by that under the FSSA Act. And this, Milords, section 89 in any case overrides all other acts. So my learned friends' reliance upon PC Act, Milords, is of no avail to the extent of what is an animal, Milords. And therefore, Milords, trying to divert the issue, if I may say so, Milords. On the second point, Milords, and I will give a note to your lordship, Milords.
Okay.
For assistance, Milords. So, Milords, the second submission, Milords, being that the main submission, Milords, here is the issue in hand before your lordship is only whether the chief secretary was authorized or not authorized. Yesterday, I had taken your lordship through section 86 and article 256.
Yes.
Section 86 of the FSS Act and article 256, of course, of the Constitution. Milords, section 86 is plenary powers, Milords, to issue all directions necessary to carry out the provisions of this Act. Now, my lords, this is there's a judgment, my lords, of course, a single judge. I must mention to your lordship, honest Raja, which is, my lords, I'll just send it to your lordship. My lords, is paragraph 62 of your lordship, page 62, which refers to section 86 powers, my lords. Then, my lords, Article 256, which I had read out to your lordship and referred to in Swaraj Abhiyan in the context of Food Safety Act, my lords, where states are to take necessary action to implement central law. These two, my lords, I'm just repeating, my lords. My learned friend, my lords, referred to three sections. Section 18F, which are the duties of the Food Safety Commissioner to inform the public. Section 30, bracket 2, bracket A, my lords, which is only a prohibitory power for 1 year only and within the state. It is not for nationwide standards and prohibition. And section 33, which deals with prohibitions of persons convicted of an offence under the Act and does not deal with general prohibitions. So, my lords, again to reiterate the same point, my lords, any of the other provisions is not an issue here. Whether food commissioners have other powers, my lords, we are not there. Does section 86 give powers? The answer with your lordship, my lords, will have to come from your lordship, my lords, to confirm the submission made by us that the powers, plenary powers are there under section 86 and those have been passed and sustained. Article 256 again, my lords, dehoards the Act. In addition, I shouldn't say dehoards, my lords. In addition to the Act, the Constitution, which is supreme, my lords, empowers the centre to direct the states to take necessary action to implement central laws. And Food Safety Act, my lords, is a central law, and the food regulations are, my lords, made under section 92. 92 to E, my lords. And these are the regulations, my lords, which are so prescribed. Then, my lords, on the third submission of the respondents, that there is no power to ban dog meat under law. My lords, these are punishable offences. So, my lords, section 11(1)(L, read with section 11(3)(E of PC Act, Prevention of Corruption, Prevention of Cruelty Act, and section 325 of BNS, the new criminal law. They provide for a penal offence to kill an animal except for food.
Yes.
Because what is food, my lords, is defined in FSSA as live animal prepared for placing on market for home consumption, human consumption. And for purposes of live animal, my lords. The definition of animal in FSS, my lords, I just read it out to your lordship in regulation 2.5.1, is defined as only specifically 5 species of animals. Canines, bovines, I read out to your lordship, my lords. With a specific definition, my lords, again I reiterate, we can't go back to any other provision of law. And this, my lords, Ethiopian confirms the position. The reference, my lords, to the relevant prohibitions under IPC was made by the Chief Secretary, my lords, in the notification, which is impugned before this honorable court, my lords. We are, of course, in writ appeal. And this, my lords, notification of lordship will just see this, my lords, on page 161. Of the writ appeal. This was under the erstwhile Indian Penal Code, my lords, and the Prevention of Cruelty to Animals Act. I've got that, please.
Yes.
Any person found violating this order at the bottom, my lords, clause 5. This is the notification impugned, my lords. Any person found violating this order shall be liable to be punished under section 428 and 429 of the IPC 1860 and section 11 of the Prevention of Cruelty to Animals Act and or such other provisions of law as may be applicable. So, my lords, it is not only, my lords, what happens, my lords, in law, prohibition is a civil statement. Punishment is, my lords, subsequent to the offence having been committed. So, my lords, whenever anything is an offense, simpliciter, my lords, the power to prohibit the same is there inherent in law, my lords, and can always be, my lords, imposed in as many, my lords, terms, and punishment has been specifically prescribed under this, my lords. Notification itself. To come to the next argument, my lords, the other side, my lords, the respondents had argued, not all of them, my lords, FSSAI, in fact, my lords, supports the proposition totally in our favor, my lords. My lords, the argument made was the ban on dog meat trade compromises the right of privacy. And my lords, the reliance, of course, was placed on Puttuswamy. My lords, I had the fortune of being party to this judgment. My lords, my simple statement, my lords, in this is this. 19(1)(g), the right to carry out trade and business. Under 19(1)(g), or the right of privacy as construed by Justice Puttuswamy's judgment, are all subject to reasonable restrictions in public interest. If I may just read out Article 19(6) for a moment. Of course, your lordship knows it, but nonetheless, my lords, if your lordship could just look at it for a moment with me. There's no right in a country is over and above the rights of the general public, security, health, and other concerns. So if your lordship will see 19(6),
Yes.
nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interests of the general public reasonable restrictions on the exercise of the right conferred by the said subclause. You know, each of these fundamental rights themselves will always require reasonable restrictions in the interest of the public. And if your lordship will see the Food and Safety Act, my lords, the object and purpose of the said act, I'll just read it out to you for a moment to your lordship. Well, as it's a little lengthy, but if your lordship will just look at it.
Yes.
Statement of objects and reasons. So, my lords, the first paragraph, my lords, deals with multiplicity of food laws, etc., my lords, which creates confusion. And therefore, my lords, the need to bring in the new, my lords, law. Then, my lords, in 1998, I'm just skipping a little, my lords. The Prime Minister's Council on Trade and Industry, which appointed a subject group on this food and agro industries, my lords. Then, my lords, clause 3, then the member secretary, my lords, Law Commission was asked to make a comprehensive reviews of food laws, and it went on to do the same, my lords. Clause 4, my lords, the group of ministers constituted by the Government of India held extensive deliberations and approved the integrated law. And the bill, my lords, therefore, in clause 5, incorporates the salient features, my lords, of Prevention of Food Adulteration Act, and based on international legislations, instrumentalities, and Codex Alimentaris Commission, which relates to food safety norms. And if your lordship will then see the preamble, my lords, of the Food Safety Act, which is a clear description of the intent of the act. An act to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale, and import to ensure availability of safe and wholesome food for human consumption and for matters connected therewith or incidental thereto. So, my lords, the concerns are on all the directions: wholesome food for human consumption, safe food for human consumption, and for matters connected thereto. And, my lords, I may say that in the present petition, my lords, the appeal arising from the same does not in any manner challenge either the act or any provisions thereto. On the contrary, in fact, there is some reliance placed on the Act. There is no challenge to the Act. This Act is supreme, my lords. It's a parliamentary central legislation, has not been challenged. On the contrary, it has been upheld, directed to be implemented. And I'll just point out, my lords, the judgment in Swami Achutyanand, which in terms directed, my lords, all concerned to implement the Food Safety Act, my lords, including Nagaland, which was respondent number 3. If your lordship would take, my lords, Swami Achutyanand,
Yes.
para 35 at page 709. We have heard the learned counsel appearing for the petitioners, the Union of India, and the council appearing for various states. Your lordship will take it that state of Nagaland is respondent 3, my lords, in this matter. My lords, the submissions by the Union of India, on behalf of the Union of India, it was submitted that a fair mechanism for dealing with food safety and standards and for checking adulteration is in place. As Parliament has enacted the Food Safety and Standards Act 2006 and the regulations, which are effective in taking care of the food safety and standards, it becomes therefore important to firstly refer to the legislative efforts made by the Union of India. Parliament has enacted the Food Safety and Standards Act 2006, which is exhaustive on laws relating to food and repeals 2 other earlier laws relating to prevention of food adulteration. Preamble reads, my lords, I've just read it out to your lordships, my lords. Some of the objectives, my lords, again, to regulate the manufacture, storage, distribution, sale, and import, safe and wholesome food, my lords. Paragraph 38, my lords. The Act, apart from making stringent provisions, example prescribing higher penalties to curb food adulteration, also ushers in new concepts such as putting in place food safety management systems and food safety audit to realize its ultimate goal of ensuring availability of safe and wholesome food for human consumption. In order to ensure food safety, effective food safety systems implementation, and to ensure that food producers and suppliers operate responsibly and supply safe food to consumers, the Act further stipulates, these are various requirements. And finally, the last one, 4, if your lordship will see, the responsibility on food business operators to ensure that food processed, manufactured, imported, or distributed is in compliance with the domestic food laws. This is the action, my lords, which is being sought in the current position. And finally, my lords, if your lordship would turn over to paragraph 56 at page 718. Paragraph 56.1. In fact, let me read 56 for a moment. Considering the seriousness of the matter, and in the light of various orders passed by this court, this writ petition is disposed of with the following directions and observations. The Union of India and the state governments shall take appropriate steps to implement the Food Safety and Standards Act 2006 in a more effective manner. And then, my lords, various other supplementary steps by all food safety authorities, my lords. Plus, the states have been impelled and implored and directed and mandated by this judgment, in addition to, my lords, the orders passed by the central government to implement the food safety laws, my lords, and Nagaland, my lords, state of Nagaland is a party to this judgment, as I mentioned, as respondent number 3. And definitely, my lords, bound to do so, my lords. So therefore, the other, my lords, submission also which was made regarding the notification of FSSA, my lords, is of no avail on the ground, my lords, that one, in various positions, my lords, Swaraj Abhiyan and Swami Achutyanand, the Supreme Court, my lords, has mandated the implementation of the Act effectively, not only implementation, but effective implementation of the Act. And, my lords, in addition, the state of Nagaland itself may not have notified the law as it so says, my lords. But I have shown your lordship the additional affidavit yesterday, in which in terms, my lords, the state of Nagaland has accepted and implemented the Food Safety Act. In fact, noted the violations thereof, the implementation thereof, the website, my lords, the paper book, my lords, which was, I've shown all those pages. If your lordship wishes, I can go again, but I would prefer to save your lordship's time on that, my lords. I've shown each of those documents in detail yesterday, my lords. So it can hardly be compared, my lords, in the hands of the state of Nagaland to say anything to the contrary, my lords. And, my lords, finally, on that front, my lords, as far as this is concerned, this law, my lords, is in any case a public health law. It's a public health and safety law. It is a food law. It is not tribal law. It is not social. It is health, and health connected with safety for human consumption. So, my lords, if one takes that perspective, my lords, of the case, irrespective, my lords, also this has not been raised as any plea by anybody. This has not been the writ petitioner's contention, who are in any case business operators who are operating even without licenses, who've come before this honorable court. It has not been, this issue has not been raised by the state. It is not raised by the Food Safety Act, which is a party. And my lords, definitely, my lords, then in those circumstances, firstly, my lords, the respectful submission is that when the state itself, my lords, is following the law, implementing the law, accepting the law, mandated to act as per the law, my lords, it doesn't lie, my lords, beyond the scope of the writ petition and the writ appeal to go into that issue, my lords. Definitely, my lords, your lordships would not consider it probably appropriate, my lords, in those circumstances to even consider this submission, which is not the subject matter. And if your lordship still wishes to, my lords, go, we have, my lords, hopefully satisfied your lordship that the state has accepted this principle as party in Swami Achutyanand, as the various, my lords, publicity materials, the websites of Nagaland. So going back to 371A, just for your lordship's concern, I'll just clarify. 371A for a moment of the constitution, lords. I do believe it is not pertinent to the present writ petition subject matter, but
No, yesterday one of the council for the respondent has argued on this point.
because he's argued in a writ appeal.
371A.
Because I know, that's why, for your lordship's concern, I am still addressing it.
Yeah,
But
yeah.
my lords, it was not raised in the writ petition. It is
Yeah.
not part of the impugned order. It was not raised in the response. My lords,
Yeah.
any submission, my lords, made for the first time, my lords, nobody is challenging the constitutionality of the act.
Yes,
The
yes.
act has not been challenged. The actions thereunder are challenged by what? Challenging the act itself, which is not subject matter of the challenge. This is the position. So anyway, well, even so, let us satisfy our lordship even on 371A for a moment.
Yes, yes.
So, my lords, the special provision 371A with respect to the state of Nagaland, notwithstanding anything in this constitution, no act of parliament in respect of only these issues require resolution. So let me read these out. My lords. Religious or social practices of the Nagas. This is not religious or social practices. Naga customary law and procedure. It is not Naga customary law and procedure. Administration of civil and criminal justice involving decisions according to Naga customary law. That is below civil and criminal justice. And then below ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decides. So, my first submission is the FSS Act. I've just read out, my lords, the preamble, the objectives of the Act. The Act has to do with health, safety, human consumption. It has nothing to do with any practices of anybody, my lords, which are relevant to the purpose, and therefore, my lords, by ipso facto, there is no notification required. I'm sorry, my lords, there is no resolution so required under the Constitution, and this argument, my lords, is of no avail. And secondly, my lords, again to confirm my position, my lords, which I have so stated earlier, my lords, in pith and substance, not only in pith and substance, because pith and substance is a lower test. Food Safety Act is a complete code on health and food. But otherwise, when your lordship looks at any law, my lords, your lordship, my lords, possibly applies a pith and substance test. In pith and substance and in actuality, Food Safety Act is a health and safety for food and human consumption act. And therefore, my lords, if I may just refer to, my lords, one judgment, FN Balsara, which is 1951 Supreme Court, my lords, 860, the relevant part, my lords, being at paragraph 23. I am meeting, my lords, a test which has not even been put by the other side. I am going to your lordship so that I can fully satisfy your lordship, my lords, that all these arguments have no avail. Para 23 at page 875. State of Bombay versus FN Balsara.
Yes.
There is also another way of dealing with the contention raised before us. It is well settled that the validity of an act is not affected if it incidentally trenches on matters outside the authorized field, and therefore it is necessary to inquire in each case what is the pith and substance of the act impugned. If the act, when so viewed, substantially falls within the powers expressly conferred upon the legislature which enacted it, then it cannot be held to be invalid merely because it incidentally encroaches on matters which have been assigned to another legislature. As I said, my lord, this is a test I am simply showing your lordship. To my mind, my lords, and I hope I have been able to satisfy your lordship, that the preamble of the act deals with health, safety, and human consumption. So there's no necessity to look at pith and substance. But if it is anybody's argument that it even remotely touches any other aspect, which under Article 371A is covered, which remotely, then, my lords, your lordship cannot test it on that surface. It has to be pith and substance. It doesn't. And then, my lords, the final, my lords, point here, that means resolution is not required under Article 371(1)(a)(1) because it doesn't deal with any of these positions which are required to be so notified by resolution, but because it is deemed to be by necessary implication that the stand of Nagaland is that it is implemented it. Once Nagaland implements, lords, the state of Nagaland, with respect, implements the said law, and it has so implemented for 14 years, it cannot now be anybody's position, and that to a private parties operating without license, to come and say, my lords, that there is any requirement, my lords, by under Article 371A. The legislature, my lords, has not said anything. The state of Nagaland has accepted it. Supreme Court has confirmed it. Nagaland is a party. It was never the case of Nagaland and cannot be now any contradiction, my lords, to any other position taken earlier. And they, my lords, there is deemed acceptance of the position and active acceptance of the position that the FSSA Act applies in the state of Nagaland. And there is no resolution required, my lords. It is not, my lords, for this, for anybody, my lords, to go into the wisdom of the legislature, which is the one which was required, if anything, my lords, to do the needful. If the legislature wants, my lords, that is up to them. But the legislature accepted in principle, in action, in active practice, and consent in the matters before the Supreme Court, my lords, that this is the position and the act applies. And they've, in fact, my lords, done audits on that basis to do so, my lords. So, my lords, with this, I will, my lords, I have concluded. I'm so grateful to your lordship, my lords, and I will take the liberty to give in, my lords, just one, I'm sorry, my lords, one part. Hifzur Rahman, my lords, only para 31 for a moment, which was read out to your lordship. Some part of it was read out by the other side. So, my lords, if I may just show the relevant part to your lordship, my lords. Yes. I'll read the whole paragraph because some part was read out. The letter dated, this is at page 257, my lords. And we are very grateful, my lords. Your lordships have had a lot of patience, my lords, to hear this matter.
Yes, 257.
Yes, my lords. Para 31. The letter dated 7/6/22 has made mention of animal as an animal belonging to any of the species such as ovines, caprines, suolines, bovines, and includes poultry and fish. The Food Safety Authority of India, in its letter dated 7/6/22, has earlier referred to an earlier letter dated 6/8/14. This is the same letter, my lords, which is there in our case. Also, impugned, my lords, I believe, in the amended writ petition at page 186. So I'll just go back again, my lords. Earlier letter number so-and-so dated 6/8/14, wherein it had said the slaughtering of any other species other than the one listed above is not permissible under the FSS Act 2006 and the regulations framed thereunder. It is apposite to state that Section 92 of the FSS Act 2006 has empowered the Food Safety India, the Food Authority in short, to make regulations with the previous approval of the central government and other previous publication by notification consistent with the Act and the rules to carry out the provisions of the FSS Act. Clause E of subsection 2 of Section 86 has empowered the Food Authority to notify standards and guidelines in relation to articles of food meant for human consumption under subsection 2 of Section 16 of the FSS Act 2006. And this, my lords, is ultimately, my lords, this provision, my lords, the regulations are with the previous approval of the central government and after previous publication as noticed, my lords, which carry the sanctity, my lords, of original, my lords, legislation. And then if your lordship will just go forward, my lords, in this paragraph. The Food Authority and Excise has made a set of regulations. Regulation 2.5.1 of 2011 regulations has defined animal, and animal means an animal belonging to any of the species specified below. Again, my lords, reiterating, both the letter dated 4/7/16 and the letter 4/7/6/22 of the AWBI has mentioned that the definition of animal has effectively meant that camels cannot be slaughtered for food at all. This part of the directive contained in the letter dated 7/6/22 has not been specifically assailed by the petitioner in this writ petition. Huh? Well, this is pari-materia, my lord. These letters are identical. In fact, my lords, it was surprising to find that the identical issue had been considered, of course, in the context of camels, my lords. But the point, my lords, is still the same. In this case, of course, it is dogs, my lords. Single judge is not citizen. And my lords, the single judge in the present matter has not set aside, my lords, the 2014 circular of the central government. So therefore, my lords, that stands. That's the central government directives which have been implemented by virtue of Section 86 and Article 256. I should say Article 256 before, my lords, but either way. So, my lords, that circular stands. That is not so assailed. We are the ones, my lords, in appeal only on the count of the authority of the Chief Secretary. That's a limited point. Every other point has been held in our favor. That dog meat is not food. In terms that has been held in the impugned order, the FSS Act has been considered in detail. Each and every provision considered and found to be in consonance with human safety. The only part was the authority of the Chief Secretary, which I hope we have been able to satisfy our Lordship, my lords, on the fact that not only is it justified by law, it is also justified and reiterated and reconfirmed by the Supreme Court. It has been reconfirmed by the state of Nagaland. And that's I rest my case. And that, my lords, we'll take liberty to give a few submissions, my lords, just the same. I would not be giving anything additional to your lordship for your convenience, my lords. May we have, my lords, 3 days to do so? We'll give it today, my lords. Very well. Tomorrow, don't make it today. Tomorrow, my lords, we'll have it into your lordship, my lords.
Tomorrow.
Can we, yes. Can we have emails, my lords, of your lordship? My lords, ask the court master to give us the email so that we can send it to your lordships directly, my lords.
Yes, the courtmaster will give it to the council present here.
So, I'm so grateful, my lords, because then it will come to your lordships, my lords. You won't have to go around, my lords, into different domains, my lords.
Okay.
Very
Okay.
grateful, lords.
Okay. Yes, Mr. Singhvi.
Yes, my lord. They are just quick points I will make, my lords.
Yes.
First, I will go, my lords. Article 371, capital A.
Yes.
Every law will automatically stands implemented in the state of Nagaland unless it touches 4 points, my lord: religious or social practices, Nagaland customary law and procedure, etc. As it is stated, the state of Nagaland has thought it proper that it doesn't concern, the Food Safety Act doesn't concern any of these 4 enumerated heads, which are exhaustive in nature, and therefore they have decided to implement the same. Now, my lords, there could be a scenario. I'm not ruling it out, that a citizen feels that yes, it comes within these 4 enumerated heads, but he has to lay challenge to the wisdom of the legislature or the government and say that even if it covered the four heads, still you did not pass a resolution and therefore it is bad in the eyes of law. That scrutiny will be very high, man. And for that, there is specific averments have to be made, a specific prayer has to be made, and my lords, they have made a prayer to the contrary. Kindly see the writ petition, my lords, in my appeal, my lords. Writ appeal 12 of 2024. Kindly turn to page 94, my lords. They have said to the contrary. My lords have page 94.
Yes.
My lords, paragraph 5.6 of the writ petition.
Yes.
That, however, without prejudice to what has been stated above, it is submitted that this petition does not seek to address the justification of dog meat in the state of Nagaland in the context of culture and customs.
Yes.
They say that we don't want to, but they could have ascended. I am not saying that one. But they have said to the contrary, that we don't want to challenge on the grounds that it is a part of the Naga custom or social practice or etc. They have said to the contrary. Today, how can they argue to the contrary to their own pleadings? This is my first submission with regard to Article 371 capital A. If the legislature has decided not to pass a resolution, it doesn't mean that the act is become a void. No, to the contrary, act is a valid one. Now the only point is, if somebody wants to say that the act becomes a invalid act or it becomes a void act because it comes within the purview of the four enumerated grounds, specific averments have to be made, and they have made a contrary averment. How does the state meet this argument? So this argument is without any substance, contrary to pleadings. In the pleadings, they say it does not seek to address a justification on the ground of culture and customs. Then, my lords, if they had pleaded, then my lords, the state would have responded. Then, my lords would have very heightened scrutiny whether it is part of Naga custom or that would have been an entire exercise altogether. Today, off the cuff, off the record, contrary to record, what they state in petition, they argue, my lord, this is my first submission. So, my lord, that point of Article 371 capital is not made out the pleadings. To the contrary, they say, we don't want to make this pleading. This is my first point, sir. The second point, my lord, was about the right to food as a choice. My lords, I haven't come across, subject to correction, that Supreme Court has declared right to eat of his own choice as a part of fundamental right. This is my second summary. One of the basic point which has been raised is about the food being a very wide encompassing, and therefore, my lords, it cannot be confined. My lord, this entire act is about food safety. My lord, kindly see the inherent fallacious argument. They say the food will include dog meat, and then the entire act is about food safety. So, my lords, wherever they permitted slaughter, they have mentioned about it. Where they have not permitted, they have not acted upon. They say that what where we have permitted, we have acted. Kindly see. Tomorrow, my lords, camels can be cut, my lords, slaughtered. Elephants can be slaughtered. Therefore, they have confined it to certain animals. It is not that the animals which are not being enumerated, that food can be consumed or that can be slaughtered. Wherever the legislature feels that yes, these are the animals which can be slaughtered for consumption of human food, they have allowed it. By expressly the other animals which are animal species stands excluded. They added rabbits. Why they did added rabbits? Because they felt that no, rabbit is a staple diet of the people, so they added rabbits. Later on, 2017. So the legislature takes a conscious decision that which are the animals which needs to be slaughtered for human consumption. It cannot be that what is not included can be slaughtered anyway. That is why Mujibur Rahman's judgment is with regard to camels. And my lords, this is a very fallacious argument that whether we are coming under the food, therefore if we are not under the animals, we can do it. To the contrary, the overall scheme is it defines the food in a wide manner, but it says that yes, these are the animals which can be slaughtered for human consumption, otherwise not. So that is the wisdom of the legislature. Now, my lords, therefore, the wisdom of the legislature to include only certain animals to be slaughtered cannot be doubted. Now, what the other argument is, the third argument was about the prevention of this Cruelty Act. That is with respect to animals which can be slaughtered, how they can be how they have to be slaughtered, how the slaughterhouse have to be maintained. It is with respect to that, the rules of 2011. It is not that animals which cannot be slaughtered would give the right to be slaughtered, my lords. Slaughterhouses rules will apply to those slaughterhouses in which animals which are enumerated in the act can be slaughtered. So that's a separate occupied field. It doesn't give a license to kill or to slaughter the animals which are not enumerated in the Food Safety Act. Food Safety Act is a very different field from the Prevention of Cruelty Act with respect to the slaughterhouses. That was an argument which was canvassed. So, that is a separate field. And my lords, because slaughterhouse rules are there, animals are defined, that doesn't mean that you can kill all the animals. To the contrary, if there is a restriction in Food Safety Act with respect to the meat which is fit for human consumption, it has been enumerated. Now, my lords, therefore, my lord, this argument again, my lords, lacks any substance. Now, my lords, the main argument on which, the main point which was held favor by the, my lords, by the division bench was twofold. May I, my lord, para 36. One, it doesn't have the legislative backing. Second, that what is stated in law has to be followed. That is since Prem Nazir's case. And therefore, my lords, these were the 2 points which were canvassed before the Honorable High Court, which found favor with the Honorable High Court. Now, my lords, kindly turn to both the arguments. First point is, this has a legislative backing because it has been issued under 16(5). Therefore, my lords, it has a legislative backing to which there was no rebuttal in the arguments also. So they also, my lords, practically agreed because my lords, all the argument was on, my lords, 6th of August 2014, right to food, etc. 6/8/2014 has not been set aside, my lords. It is operative in the state of Nagaland. Both the act and the notification of 6/8/14 is operative in the state of Nagaland as on date. Now that is very clear. Though they had amended the petition, but my lords, it was in the few paragraphs, initial paragraphs of the improved judgment, it has been, my lords, even stated. But my lords, later on, I don't know, my lords, we were not there, whether it was given up or not considered. I think it was given up because they have not argued that it was argued. Therefore, my lords, 6th of August 2014 notification, which is the source of entire power, is not set aside. It is not, no appeal has been filed against that. If I am subject to correction, because there are only 2 appeals which are listed today. So as long as 6/8/14 notification is there, my lords, what are the contours of, my lords, how the Nagaland one is? Kindly see, my lords, the main argument which was, my lords, which my lords also had, my lords, main argument, main contention which was accepted by the High Court was that the law does not permit the Chief Secretary to pass. Kindly see 16(5). I will just read it again, my lord. Very important, my lord, section 16(5). The Food Authority may from time to time give such directions on matters relating to food safety and research to the Commissioner of Food Safety, who shall be bound by such a while exercising the power. The argument is that the Commissioner of Food Safety would be exercising the power. Today, the Commissioner of Food Safety ought to implement the notification of 6/8/14, even if, my lords, for the sake of arguments, even if the notification of, my lords, is 2nd of July 2000 is set aside. Even if the judgment, my lords, is upheld, still the notification of 6/8/14 would be an operative. Is as on date it is operative, my lord. Not asset. It was asset before single judge, not set aside. No appeal filed against that order. Therefore, my lord, 6/8/2014 is an operative law. The Commissioner of Food Safety at least has to implement that law. That the contents of the circular dated 6/8/2014. Now, my lords, we come to the power of the Chief Secretary. My lord, Chief Secretary is head of the executive in terms of implementation. If there is any inaction on part of the state government, it is not the legislature, or it is not even the elected representatives who are answerable to the court. It is the highest executive represented by the Chief Secretary of the state and Cabinet Secretary in the case of Union of India, who is responsible for all the actions of the government. Therefore, the Chief Secretary has issued a circular which is innocuous in nature to all the police personnel, all the relevant authorities, that please implement the direction. Well, it is not that he is trying to, it is not that any notification had to be issued by the Food Commissioner. Food Commissioner was to obey. It doesn't mean that the state government can say that only Food Commissioner will, my lords, implement. Whereas I'll give an small example, my lord. That suppose there is an MCD. Court directs that that these buildings are encroachment on the land, please demolish it. The Chief Secretary or the Secretary would be responsible for holding that, yes, not only the MCD Commissioner, but the police personnel will be required. Sometimes even the local representatives may be required. And the the concerned Secretary may take meeting of all the stakeholders to see to it that the encroachments are removed in a humane and in a just manner. What is wrong about it? It is not that the MCD alone is responsible under the Act for the encroachment. The Secretary will not do nothing. So it is Chief Secretary is only a supplement. And my lord, the judgments of Swaraj Abhiyan and Achyutanandan, which was pointed out by a learned senior friend, she had pointed out that these two judgments directed the state governments to implement the provisions of the Act. So if they just 6th of August 2014 is a valid operative circular, then why can't the Chief Secretary state that please implement it the same? He's not applying his independent mind. He's not discharging any statutory duties under the Food Safety Act. He's not replacing any duties under the provisions of the Food Safety Act. In fact, he's acting as a supplementary. Executive action can always be supplement to the legislative or quasi-legislative action. He's only saying that please implement this circular also. So his notification or his not notification, it's just a direction. Municipalities Act govern the entire municipal fees, but the Secretary can always say, please remove the encroachments, because he is answerable to the minister and then thereby to the assembly. And sometimes in PIs, my lords, even to the courts. Therefore, my lords, this is how the things work. Chief Secretary it is not that Chief Secretary is usurping the power of any authority under the Act. He is acting in supplement and not in derogation and not in supplanting any powers under the Act of Food Safety Act. Even if the Chief Secretary, my lords, today circular is set aside, then also, my lords, by virtue of the prevalence of 6th of August 2014, the Food Commissioner will have to, my lords, implement the Act. And if he finds some difficulty in implementation, he will require, sometimes he may require police personnel to do so, to ensure his own safety. Therefore, my lords, to hold that he was usurping any power or he was exercising power, divorce the Act, he was only acting as an executive power to supplement the provisions or the directions which are issued by the central government. This is my lords with regard to the powers of 22/7/2000, which in any way is residual power of executive, not in addition to and not in derogation to the powers which are mentioned in the Food Safety Act, is my humble submission, my lord. Now, my lords, the other point is, my lords, with respect to Article 21.
Yes, just one question, query.
My lord.
So Section 30, Commission of Food Safety of the state, say
my lord,
the state is, shall appoint the Commission of Food Safety for the state for efficient implementation of food safety and standard and other requirements. Where do we find the name of the Chief Secretary in this?
Correct, my lords. Chief Secretary is not implementing, my lords. I'm sorry. Chief Secretary is Commissioner Food Safety, I'm obliged for this, I'm very obliged. So the Commissioner Food Safety will implement 6/8/2014. Even if 22/7/2000 is set aside. I meaning even today, according to us, the Commissioner of Food Safety would have to implement 6/8/2014. He has to do it. Suppose that tomorrow a petition is filed before this court. I'm just hypothetically stating, my lords, without making any this thing. That yes, 6/8/14 is a valid notification. Why Commissioner of Food Safety is not acting? He will have to implement. Now, when he starts implementing, the Chief Secretary will say, he can go to the Chief Secretary, please provide me with the police personnel. Please direct the collector to cooperate with me, because he may not be having the entire personnel to carry out the provisions of the Act. So the Chief Secretary may issue direction that there is a central directive, please do the needful. What is wrong in it, man? I ask myself this question. It is not that the Chief Secretary is raiding the premises, or the Chief Secretary is carrying out the purposes of the Act. He is only saying, please comply. It is not that the powers which are mentioned under the Act have been usurped by the Chief Secretary. It is not that Chief Secretary is raiding the premises, or Chief Secretary is doing whatever the work. He is only saying that please comply with the directions. He is issuing to all of them. He is issuing to the collectors. He is going to district magistrates. He is directing to all the police personnel. The main work is still may be done by the Commissioner of Food Safety. But other organs of the state are required to implement the directive of the central government, which is the state is bound by it. And the state does not argue to the contrary. Or the assembly has not acted contrary that yes, this act will not apply. To the contrary, they are implementing the rules of business. My learned senior colleague had pointed out how their state of Nagaland is implementing the same. So, 22/7/2000 has to be seen as a sequel or as a supplementary compliance directive and not as the main source of power. This is my main submission. The main source of power remains under section 16(5) of the Act, which is not assailed. That is the directive of 6th of assailed but not set aside in direct of 6/8/2014. My lords, what happens is in
2014 is executive circular only.
No, it is a central government under 16(5), read with 86, point which was covered by my learned senior colleague. Kindly see 6, my lords, kindly see. It is a directive under section 16(5). The power is, my lords, it is not by the Union of India. It is not by the Union Secretary. It is by the Food Safety and Standard Authority of India. My lords, may turn to page 193 of my writ appeal. Writ appeal 12 of 2024, page 193. It is Food Safety and Standard Authority of India. So it is a power. It is issued under section 16(5). And it is, my lord, it is addressed to all the food safety commissioners. So Food Safety Commissioner of Nagaland is duty bound even today to obey this particular directive. And apart from Food Commissioner, Chief Secretary also said that yes, my lord, and kindly see Chief Secretary's order. It is not usurping. It is saying that please comply. So it is arguing. It is giving to all the, my lords, Government of Nagaland, Director, Deputy Commissioner of all districts, Commissioner of Police Department. It is addressing, please comply with this directive. Ultimately, compliance is not the Compliance of any directive or any law. My lord, let us forget about this directive. Compliance of any law is not that it is the Chief Secretary is ultimately responsible for compliance of any law passed by any government. It is responsible through Minister, my lords, to the Assembly. It is responsible to the courts in the PIL matters or any matters which the court asks, what have you done for compliance? So it is a compliance notification. I am repeating, my lords, with due respect, my lords, for the sake of my lords' repetition. It's a compliance sequel directive and not the source of power. And Chief Secretary is bound to comply, is bound to issue directions to all authorities for complying. Food Commissioner, Food Safety Commissioner under 16(5) as has been is to obey the rules. Very well, my lords, he can, my lords, but he needs support because people are open shops. He might need police personnel to close the shops. He may need the help of the collector to close the shops. What is wrong in the directive? It is supplemental. The Food Safety Commissioner would require the help of the administration to carry out the provisions of the Act, for which the Chief Secretary has issued a general direction instead of having a one-to-one, standalone direction for one shop, two shops. He says that all DMs of the state, all the police commissioner, all the police officials of the state will cooperate. That's it. It is not one of usurping any function which has been cast upon the Food Commissioner. It is a supplemental. Today, Food Commissioner, my lord, as on date, as we are, I'm arguing this case, my lord, in absence of any appeal filed against the order, and the impugned order not having set aside the order of 6/8/2014, the Food Commissioner Safety is bound to comply, and even the state government is bound to comply. So if the state chief secretary says, please comply, what is, I ask myself, there's nothing wrong about it. So as to say that, that there will be no compliance of the order of 6/8/14 because the chief secretary has said so. The arguments of the respondents and the petition before they would come to this point, simply because chief secretary has ordered for compliance of a law, the law should not be implemented. It becomes bad in the eye of law.
Okay. Do you have any other point?
My lord, there is one more point, my lord. Then, my lord, there is one judgment of 2006 for SCC. And my lords, as an addition, my lord, the judgments of Supreme Court are very clear that please implement FSSAI. And my lord, normally chief secretaries are, my lords, held accountable for implementation of any act, including the Food Safety Act.
What is the page number?
2006 for SCC 327 is what they cited, my lords, yesterday.
Okay.
My lords, I am trying to just highlight what the issue there was. The issue was that certain, my lords, in the Excise Act, they said that please, in the Excise Act, they also wanted to regulate the conditions of the workmen. To that, the answer was conditions of the workmen, there is a separate regime altogether. So you cannot, in the Excise Act, Excise Act to regulate this, my lords, regulate the liquor shops, etc. You cannot have the conditions of workmen. That's the sum and substance. My lord, this case helps us because the PC Act pertains to, my lords, regulating the slaughterhouses, not the animals which are going to be slaughtered. Animals which are going to be slaughtered fit for human consumption would be governed by Food Safety Act. The Food Safety Act will determine which are the animals which can be slaughtered and how the business has to take place. So this judgment doesn't help them. It contrary helps us, my lord, to converse our submission. And now there's one more important aspect I would like to, my lords, highlight. My lords, I am given to understand, subject to the correction, my lord, that the writ petition was filed by 3 traders. This is very important, my lord. Therefore, my lords, the argument yesterday was that food safety act is only for commercial purposes. It is not for, this is precisely our submission. Trade in dog meat comes as a commercial purpose. So what they can claim is 19(1)(g), for which there can be reasonable restriction. I don't think, my lord, subject to correction, my lord, because sometimes, my lord, because we were not the part, we were single judge, so sometimes we don't know there may be one person who is. I have not found that a consumer coming to my lords and saying that I have a right to food. The limited rights are sell to food, which is 19(1)(g). And in any case, I have stated, my lords, that right to food of his own choice, right to food is a fundamental right. Several judgments. But to right to eat a particular food, according to us, may not be, my lords, because this is a subject matter of Article 48, etc. It is not maybe some mention line here and there, my lords, I don't deny, but it is not on which the Supreme Court has, my lords, given authoritative pronouncement as a ratio. As a ratio, my lord. One line, sometimes, my lords, when we write, for example, right to privacy include this, one line they may be there, but it is not a issue which has been framed in that sense, my lord. And in any case, even if the one person has a right to eat food of his choice, it has to be, my lord, determined by the food safety regulations. One cannot say I can eat whatever I like, irrespective of what is healthy, what is hygienic, what is conducive, what is safe. And my lords, therefore, my lord, that the 2017 judgment, which was cited, Rohinton Nariman's judgment, my lord, that judgment itself says, my lord, kindly turn, my lords, 2017 10 SCC, page I think 1, my lords. I am reading at page 616. So, my lords, no consumer has come to the court that I want to eat this food. It is the traders who have come who want to operate without license, without any regime of the Food Safety Act. They said because we have not been included in animals, we can do whatever we like. This is their contention, unrestrained, unconstrained by any fetters. So, my lords, even if you want to have a small egg or, my lords, a chicken, law will apply. But for dogs, no law will apply. That is their whole submission. Simply because we are traders in a particular kind of profession, my lords. Kindly turn to page 616. My lords, has it, my lord, 2017 10 SEC, page 1?
Yes.
Page 616, para 567. In view of the foregoing discussion, my lords, may I read that?
Paragraph number 517.
567.
567.
Page 616.
Yes.
In view of the foregoing discussion, my answer to question 2 is that right to privacy is a part of fundamental right of a citizen guaranteed in Article Part 3 of the Constitution. Now it is very important, my lords, what is. However, it is not an absolute right, but is subject to certain reasonable restrictions, which the state is entitled to impose on the basis of social, moral, and compelling public interest in accordance with law. Therefore, my lords, even if it is held, my lords, for the sake of submission, then also it will always be subject to reasonable restriction. Article 21 is also not unfettered. First of all, Article 21 cannot be treated by a trader. Only 19(1)(g). Secondly, right to food of his choice. As such, there is no authoritative. Some line may be here and there, my lord. There is no authoritative pronouncement where they have given a reason, my lord, ratio. And thirdly, even if it is right to privacy, then it is subject to reasonable restrictions or subject to, my lord's, law of food safety. And my lord, see, public health is so important, my lord, and public safety of food is so important. That my lords,
Yesterday, you have already argued on this point.
yes, my lords, one more, my lords, Article 25, my lord. Then my lords, I will not take more than 2 minutes. Article 25 of the Constitution. I am only pointing out how important is public health. Subject to public morality, public also, my lords, Article 25.
Yes, Article 25.
Number 25 of the Constitution. Only
Yes,
20.
yes.
Freedom of conscience and free profession, practice and propagation of religion. This is the soul of our, my lords, faith articles. Subject to public order, comma, morality and health. And to other provisions of this part, all persons are equally entitled to freedom of conscience and right to freely profess, practice and propagate religion. If, my lords, public health was found to be even superior in rights to right to faith. Here they are talking, my lords, with due respect, right to food choice. Therefore, my lords, public health is of paramount importance, public safety. And my lords, this is a domain, as I argued, my lords, it's a domain expert body. And 6/8/2014 has not been, my lords, challenged or assailed. The provisions of the Act has not been challenged or assailed. But it was challenged, sorry, my lord, 6/8/14 was challenged, but not set aside and not challenged in appeal. That would be the correct expression. To the best of our knowledge, my lord, my instruction. 6/8/14 has not been challenged, my lords. Therefore, my lords, and my lords, a innocuous, last line, innocuous order of implementation of a central law or a directive by Chief Secretary cannot mean that, my lords, the entire law will come to a standstill. Especially when the law of 6/8/14 still remains operative. That's all, my lords. We are very thankful for the patient hearing, my lords. If my lords may give 2 days, my lords, one day would be, well, by Saturday morning, we can give, my lord. It would be obliged, my lord. That's all. Written submission.
Yes, you can.
Very well, by Saturday morning.
Permit the judges court for just 5 minutes. Just to
5
clarify
minutes.
certain positions.
5
Yes,
minutes.
Yes, 5 minutes.
Okay.
Nobody is objecting against public health. We are not saying that we have absolute right as far as 1901 is concerned. We are just saying that circular is incorrect. We are saying that the regulation is right. There's nothing wrong with the act or the regulations. It is the construction that has been placed in the circular at the cost of the petition. Therefore, there's no need for the petitioners to challenge the validity or the virus of the regulation. For the past 40 years, this definition has existed. Nothing prompted. Nobody said that you cannot slaughter or consume such animals. This anti-definition has existed. Suddenly disappeared. I have explained the context. I'll refrain from reiterating myself. Also, secondly, circular. The circular, it has not been, of course, expressly set aside, no doubt. But the learned civil judge has expressly held that it is beyond the power of the food authority to have issued the circular with that specific sentence, which I have been deliberating upon. And therefore, the circular cannot be the source of policy. Also, regarding Article 371A, of course, this was not the primary argument, which I also stated yesterday also. Now, this question fell from the court on the earlier dates as to whether regarding the position of 371A, and in view of the language which has been used in 371A, yes, in view of the language which has been used, it will not amount. My humble submission is that any act of parliament which infringes upon ABCD clauses, and food definitely being a part of the culture and custom of a community, it is a part of the social practice. The term social practice is a very broad term which has been used in the Constitution. Now, the non-obstante clause has been used in 371A. Therefore, if we are to accept the circular as being correct, then the act of this act cannot be applied unless the Assembly by a resolution so decides. That is the explicit language used in 371A, and because of this, I have addressed this honorable court. And this being it's not a question of fact only. The argument arises from the facts already placed on record. It's a question of law which can be raised at any point. It can be raised before at any stage of this proceeding. Yes, those are the points which I just wanted to submit, resubmit. I'm grateful.
Well, if I maybe give 5 minutes, I will not take more than 5 minutes.
Okay.
Thank you, my lord. Lordship, 3 short points. In the Food Safety Act, license and registration of food business, there is a clause which says that it shall be ensured that the dogs, cats, or birds do not have access to the slaughter halls. Open areas in the factory shall have covered wire rope netting to prevent such and such lordship. So this itself clearly indicates that the framers of the regulation had no idea that some communities in India consume dog as meat, and therefore at para 32 of the impute a single bench decision, lordship, the Honorable Justice had rightly observed that the thought of consuming dog meat was alien in most mainland Indian areas, lordship. First point. Second point being, lordship, that the order which had been quashed, issued by the Chief Secretary, lordship, therein it had been mentioned that those who indulge in sale and transport of dog meat would be punished under Section Section 11, Prevention of Cruelty to Animal Act, and also for the offense of mischief. Yes, IPC, lordship. So there, if my lords were to look at the my apologies, lordship. As per the notification, one is to be punished under Section 428 and 429, and lordship. 428, mischief by killing or maiming animal of the value of 10 rupees. Section 429, mischief by killing or maiming cattle, etc., of the value, or any animal of the value of 50 rupees, lordship. If my lords were to look at Section 425, which describes mischief, this is an ingredient of the 2 offenses which I've read out earlier, lordship. When the definition of mischief is read, it is found that mischief pertains to this causing destruction to public property or to another person's property, and therefore, for the purpose of this notification, the dogs, theoretically, if I bought them, it is my property, and therefore technically a conviction can never be sustained under these sections, and therefore for that reason these 2 sections are defective for this purpose. And insofar Section 11 is concerned of the PC Act, blanket statement that a person can be punished when he indulges in sale or transport, commercial sale of dog meat. Each case will have to be the law will have to be applied in its course, own facts and circumstances, and a blanket statement surely would not be effective in that sense. Lordship, my final contention is that, lordship, it is well settled law that in an intra-court appeal, unless there is patent illegality in a single decision, the decision should be upheld. Here, lordship, the issue has been discussed at length. The single bench found that there was procedures. The Food Safety Act is most comprehensive, and therefore the Food Safety Authority has clearly made an overreach. It has exercised powers which it has not been empowered for. So therefore, those 3 points I wanted to raise, and permit me to just furnish one decision, though it is well settled law. What the settled law when it comes to intra-court appeal is, I'll just furnish one decision, lordship. I've given a book list, 2014 volume 1 GST.
Kindly slightly.
I'm sorry.
Sorry.
It's I'm sorry, 2004. I'm so sorry. 2004 1 GLT 11751. 117, sir. 2004 1 GLT 117. Lordship, the paragraph I'm relying on is at para 26. Lordship, for the same time, I'll just be reading from the middle portion. Yes, Lordship, from the 5th line, thus, unlike an appeal in general, a writ appeal is an appeal on principle, and that is why, unlike an appeal in an ordinary sense, such as a criminal appeal, where the whole evidence on record is examined by the appellate court, what is really examined in a writ appeal is the legality and validity of the judgment, and or order of single judge, and it can be set aside or should be set aside only when there is a patent error on the face of the record or the judgment is against the established or settled principle of law. Lordship. I'm deeply obliged.
Okay.
Obliged for the patient hearing.
Yes,
Your-
heard Mr. Singhvi, learned senior counsel assisted by Mr. Are you assisting?
Yes.
Okay, Mr. Fosiko Pote?
Three.
You,
Yes.
good name?
3 agreements.
Learned counsel for the appellant in writ appeal number 12 of 2024 and Mr. Iralo here.
L. Iralu. For
Learned counsel for the respondent number
23.
23.
123.
123.
Will be the bill 7.
No, in 12.
Of only 12.
For respondent 1, 2, and 3 in 12.
1, 2, and 3.
Yes, madam.
1, 2, and 3. And Ms. Sokeri for respondent number 4 and 5. Respondent number 4 and 5. Argument concluded, judgment reserved.
Your Lordship, may I please, Your Lordship? Your Lordship, I'm appearing for respondent number 6, so let my presence be also recorded.
Respondent number 6, your good name, please.
Catherine,
You are appearing in writ appeal number 12.
12 as well as 7.
Okay. In both the matter?
Yes, Your Lordship.
Okay.
Perhaps Lordships, Lordship may be gracious enough to note down the names of the counsels assisting the senior advocate in Yanam.
Okay.
Yes,
Okay.
that's the list of the advocates.
Okay, give it to the
Yes,
secretary.
highly obliged.
Heard Ms. Pinky Anand, learned senior counsel assisted by that list.
Yes,
Okay.
list. With the list.
And Mr. Iralopo,
Focus
are you here?
1, 2, 3.
1, 2, 3.
7 of 23.
Yes. And Ms. Sukeri for respondent number 6 and 4 and 5. And Ms. Yes.
Catherine,
For
respondent number
respondent
6.
6.
Yes,
Respondent
Your Honor.
number
Yes,
6.
Your Honor.
Argument concluded, judgment reserved.
Obliged, my lords, for such.
Obliged, my lord.
Tuesday.
Itu ekta lado tu CJ la CDM lado. Ini kodo baru na. CJ CM lado ekta. Itu gitu. Kya bana itu protection ekta. Disposal.
이제는 이슈도 뭐예요? 걔들이 파이널 분노는 해.
Oh, kya bana na. Hoy jo prote.
너무 보내기고.
Hoy jo.
뭐 여기 이제 파이널 디비전 매치 되구나.
Hoy jo kune tu.
라서 때 형이도 이제 이슈도.